somebody purchased a property before they got married. I actually had that also happen with that same customer, where she had purchased the house that she was in. She purchased it before they ever got married, and then that was another big learning experience for me, because again, I was just taking everything that she had said at that value, and she was telling me, oh, my attorney said this, this, and this, and I was like, okay, and I just followed that lead. But we ended up having challenges because her husband, the divorce wasn't final yet, and he had lived in the property that was their primary residence together for multiple years, even though she purchased it before them. So I understand there's a difference between if someone owns property before they got married that was, say, an investment property, or if somebody owns property that was maybe their primary residence as a married couple. But what are the things that somebody needs to be mindful of when it comes to that? When they have property that they purchased before they got married, but now they're going through a divorce, what impacts could that potentially have?
Yeah, so in Florida, what the court's concerned with is not so much the use of the property, but when was it purchased and how is it titled? So it's obviously very a fact-intensive situation when you have a property that was bought before the marriage, and there might be some renovations or improvements to it made during that time. But the court's first inquiry is, if there's a property that was bought before the parties were married, was it ever retitled in both parties' names? So that's really question number one. If it was not, and it's only owned in the original owner's name, then that property can't ever be awarded to the spouse. If it was retitled during the marriage, then it would be deemed a marital asset and would be subject to the court's division. If it continues to only be owned by the original owner, then the next question becomes, well, what is the other spouse's potential interest in the property? And that's also very fact intensive, and there are a couple considerations, including if there's a mortgage on the property, if there were improvements or renovations, and also was there any appreciation. So it is possible that if you're a non-owner spouse and you're married to someone who had a property from before the marriage, you may want to consult with someone and sit down and ask them these questions, because you can possibly make a claim in your divorce case that as the non-owner, you have an interest in the appreciation in the property from the date of marriage until the date of filing for divorce. And that's kind of a calculation that's going to be done within the divorce case once you make that claim, and will depend on several things, including what money was put into the house, and then just due to market forces, the value of the property, date of marriage versus the date that the case was either filed and or the judge finalized the divorce case.